Section 91. Section 91 deals with licensing of related patents. This is the second type of compulsory licenses. We had already mentioned that compulsory licenses under the Patents Act fall into four categories. Category number 1, which is the general category, pertains to section 84. The second category is section 91. It's a different type, the grounds are different, the operation is different, and even the way in which you get a license, the reasons for which you get a license are also different. Apart from 84 and 91, we have 92 and 92A. So, these four categories comprises the four different types of compulsory licenses that can be granted under the Act. So, now let us look at section 91. Before looking at section 91, you need to bear in mind the procedure and the grounds for the grant of a normal compulsory license, what we call the default compulsory license under section 84. We need to bear in mind the grounds on which it can be granted, the procedure that needs to be followed, how long the license can be kept, and the powers of the controller in granting these licenses, that is section 84 till section 90. So, you need to bear the details from section 84 to section 90 in mind, so that you understand 91 better, because 91 presents an entirely different picture of the use of compulsory licenses. Now, 91 specifically pertains to related patents. Related patents in the sense that you have a patent, and in the same field of technology there is a related patent which does not belong to you. Related in the sense the technology is so close to your technology, or for instance you cannot work your patent efficiently without infringing the other patent or without use of the other patent, but the only difficulty is that the other patent belongs to another patentee. So, in such cases you could approach the patent controller seeking a license of a related patent. Now, the criterion here is that your technology and the technology covered by the related patent, another patentee's technology, should be related to one another. It cannot be chalk and cheese, it has to be related, there has to be some connection between these two patents. In that case, if you are not able to work your patent without seeking a license from the other person, and the other person is not willing to grant a license to you, then you can approach the controller for a compulsory license. Rather, the only ground on which you can seek a patent is that you cannot work your invention effectively because of another patent, and the patentee of the other patent is not granting you a license, and these two technologies or the inventions covered in these two patents are related to each other. Now, you will see how different this is from the compulsory licenses that are granted under section 84. 84 had certain grounds, reasonable requirements not met, affordable price not met, not worked locally. This does not pertain to any such ground. The only requirement here is that you cannot work your invention without the use of another person's patent, and that patent is not being made available to you on a license. Now, let us look at the details of this section, and just how the grounds are different, this provision operates is also different. We had seen in 84 that the patent should have been granted, and it has to be 3 years since the patent has been granted, and only then you could make an application for a license, compulsory license under 84. 94 does not have a similar requirement, and in fact you could say that 91 does not have a similar requirement. In fact, you can look at the procedure in 91, it appears to be a fast track procedure, because here is a situation where a patent is available, or the patentee is not able to work his invention effectively, not because of any difficulty from his end, because there is another patent and he is not able to get a license to that patent. So, this is more like enabling technologies to be worked more efficiently. You might have heard about technology hold up or patent hold up, when patents can be used to hold up others from working around or working in a particular technology. So, 91 solves the issue of patent hold up. If you are working in a related technology and if you find that there is another patent that is hindering your working, then you could seek a license. Now, let us look at the details of this section. 91(1). Notwithstanding anything contained in other provisions of this chapter, which includes section 84 and a default section compulsory license under that section, at any time after the sealing of a patent, we had already mentioned sealing is a remnant of the past which the last amendment didn't take care of. You should read that as at any time after the grant of a patent. Sealing used to be a step before the grant of a patent. Now it's no longer relevant, and the last amendment to the Patents Act actually removed all evidences of sealing except in this chapter, the chapter pertaining to compulsory license. So we read this as at any time after the grant of a patent, any person who has the right to work any other patented invention either as a patentee or a licensee thereof. So the requirement under 91 is that you should have some right to work a patented invention either on your own as the patentee or as a licensee. Exclusive or otherwise, so it covers both exclusive and non-exclusive licenses, may apply to the controller for the grant of a license of the first mentioned patent on the ground that he is prevented or hindered without such license from working the other invention effectively or to the best advantage possible. Now, the patentee is not able to work his invention effectively without a license of another patent which belongs to another patentee. 2. No order under subsection 1 shall be made unless the controller is satisfied 1. The applicant is able and willing to grant or procure the grant to the patentee and his licensee, if they so desire, of a license in respect of the other invention on reasonable terms. This is nothing but cross licensing. The applicant who seeks a license of another person's patent should be willing to grant a license of his own patent. So he should be willing to cross license his patent. And 2, that the other invention has made a substantial contribution to the establishment or development of commercial or industrial activities in the territory of India. So the other patent for which this license is sought has made some substantial contribution to the establishment or development of commercial or industrial activities in India. So the other technology covered by a patent is an important one, and it has made some kind of a tech contribution for the commercial and industrial activities. 3. When the controller is satisfied that the conditions mentioned in subsection 1 have been satisfied by the applicant, he may make an order on such terms as he thinks fit, granting a license under the first mentioned patent and a similar order under the other patent if so requested by the proprietor of the first mentioned patent or his licensee, provided that the license granted by the controller shall be non-assignable except with the assignment of respective patents. Now, we also saw a non-assignable clause in section 84, but in this case it shall be non-assignable except with the assignment of the respective patent. So the assignment will be to the related patents as well. 4. The provisions of section 87, 88, 89 and 90 and shall apply to licenses granted under this section as they apply to licenses granted under section 84. Now, we saw that there are general provisions under 87 which deals with the procedure to be followed in 84 and 85, and 88 deals with powers of the controller in settling the terms of the license, and 89 deals with the general purposes for granting licenses, and 90 deals with the terms. For instance, we saw that one of the terms on which a license under 84 shall be granted is that the right of the license is non-assignable. So those terms will again apply in cases involving compulsory license under section 91. Now, what is important here is the grounds in 84 will not apply for a compulsory license under section 91. So we saw that there were certain elaborate grounds, and we also saw that the grounds were enumerated. What reasonable requirement is enumerated under subsection 7 of section 84. So all these details will not apply, and the 3-year time limit will also not apply in case of 91. So we can understand 91 as a fast track procedure in the sense that the 3 grounds under 84 need not be satisfied, the 3-year waiting period is also not there. So, in that sense it is fast track, and the only requirement is that the applicant needs to show that the patents are related, and the applicant should be willing to grant a cross license of his own patent, and the invention for which he is seeking a license should have made some substantial contribution.